Good morning, friend. Welcome to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. Thanks a lot for your time. Today's topic is analysis of selected adjudication orders passed by ROC vis-a-vis role of Company Secretary. As usual, this is a pet topic of Mr. Bala. No other person can be the suitable for this. So this make an exception and allow Mr. Bala only to present because he is author of decided cases as on today, as and when you say in an article, he is there. So his knowledge is immense in that, and he can analyze the different order in very detailed manner. So today's topic, our presenter is our and moderator, which is Mr. Bala. As usual, I am not going to introduce, as I told that I used to tell him I have saved his number as a person with so many degrees. So that way it is there. And today's our panelist is C.S. Tirupal. Tirupal is a fellow member of ICSI, partner at Tirupal Gorage and Associates LLP, Bangalore, a BCom graduate, and he began his practice in 2004 after serving as full-time CS in listed and unlisted companies. He is a registered IP with IBBI, having handled 3 CRP and over 30 voluntary liquidation. He regularly appears before the ROC, RD, RBI and other authorities in matters related to merger, demerger and insolvency proceeding. He was a core contributor to ICICI's Premier on Company Law and part of Company Law research team. He is a frequent speaker at forums organized by ICSI, ICAI, IMB, IOD and other institutions. Welcome, Tirupal. Thanks for your time.
Thank you, madam. Thank you to all for inviting me.
Yeah. Friends, Mr. Bala don't need any introduction. Professor Bala is with almost 4 decades of experience, having the variety of field, and he was worked with Poseco India and is a regular speaker, and he is a contributor in various organizations. So with this, I would like to thank all our panelists for today's webinar for joining us on our knowledge sharing journey on behalf of entire team of Mehta and Mehta. With this, I will say there is no need to introduce the topic because the decided case is very crucial for us to know what is the prevalent understanding and the trend or the expectation of regulatory from CS professional. We have to understand what the regulator is expecting us to behave in the pattern or understand and the interpretation. That helps this all orders understand to remove certain doubts on the interpretation on our part as a professional. So in that case, that's why we have in between always have this kind of webinar. So with this, I will just say that there will be a webinar series on ICDR starting from next Saturday. We will put a detailed mail on our website, YouTube channel, everywhere where this ICDR regulation series. It will be for more than a month. Friends, all of you are requested to join. With this, I will hand over this to Tirupal to say a few words, then Mr. Bala, and only Mr. Bala is going to start today. Thanks a lot. Tirupal, over to you.
Yeah, thank you, madam, for the nice introduction about the this proposed topic. Yeah, as madam told, you see the most of the provisions of the Companies Act have been decriminalized. Now you can't expect any court giving interpretation for the provisions. It may be a procedure, whatever it is. Now whatever is going to be heard or going to be passed in an order, it is going to be from the regulatory perspective. So in this regard, we need to have a clarity about the thought process of the regulatory about a particular provision. There are certain cases. I think sir is going to deal with like section 62 subsection 3, whether we need a special resolution before you take a loan, or if you want to convert that loan into capital, whether you should have passed a resolution prior to this. So lot of interpretation issues are there. It won't reach, this interpretation will not reach to any court, like it won't go to the court like High Court or Supreme Court. because the matter is being settled in-house through the adjudication process. So you have around 30, 40, 30 plus registrars across here and there, and you may expect 30 plus orders, also different orders for the same topic, and we need to try to analyze each order to understand what exactly the view of the ministry on this particular provision, so that we can behave correctly, so that you will not be penalized further. So this is the one area. In fact, we do a lot of adjudication orders at our end, also filing and approaching. In the proposed amendment, till date, if we see the 454 about the adjudication section, there is no scope, as the section starts with serving of so-called notice by the ROC, then giving opportunity of being heard, and then thereafter passing an order, then appeal. So there is no scope for the suo motu filings. However, in the proposed bill, which is placed before the parliament, they are going to bring the concept called similar to the 441, that is the compounding case. The adjudication also can be filed in the form of suo motu applications. They are going to pay the way for that. So with this, I think we are expecting a lot of adjudication orders on the suo motu applications, and also the so-called notice issued by the ROC, during the course of investigation or during the course of inspections, they will come to know that there are a lot of violations are there. Accordingly, they will raise the so-called notices. So let us just listen to the sir. Then I will pitch in whenever is needed. As per my understanding, I will just provide my value addition to it. Sir, kindly go ahead.
Good morning to all of you. I have a great pleasure in welcoming you all on my own behalf and also on behalf of Mehta. I am really highly privileged to share whatever the things are all happening with the adjudication front, so that will be of helpful to our profession. As we know, our institute's vision is actually to be a global leader in promoting a corporate law. That is the vision statement. With that vision statement, our mission is actually developing a high caliber professional who facilitate the governance. That is actually the vision. And another thing is, as far as the statistics, if we go through even the ICSI own survey, it says we'll be requiring around 1 lakh company secretaries by the year 2030, whereas we have, as on today, around 79,000 members or so. So that means there is a scope of lot of CS professionals or requirement. The requirement is expected to go up, especially now in the areas which are all coming up, like, what you call financial services, IT sector, manufacturing sector, all these places, the company secretaries are going to be there, because company secretaries' scope has been actually enhanced, not only complying with only the Companies Act, but also ensuring compliances of all the applicable laws to a particular company. That is what it has come in the 2013 Act, which was there earlier in the LODR regulation as such. So with these things, what happens is, today the profession is going up. We are getting more and more recognition. Institute is doing our best actually. In fact, there are specialization areas like, as Dipti said, she is going to take up the IPO in next 4-5 sessions. So IPO is one of the area. SEBI compliance is other area. FEMA is another area. The new areas which has actually come out is actually REIT, real estate, and then invite. All the things are all very good areas for us actually. We are very happy. Our profession is growing up. Opportunities are coming up. Everything is coming up. But only thing is, what I'm looking at, practice is going to be more in future. Because now what happens is, everything, the culture of change of working has happened. People can work from home culture, which has actually come, especially after the COVID. By sitting anywhere, any place, you can service. All those things are going to be there. But again, going back by the survey, there are hardly something between some 13,000 to 15,000 people are actually actively in practice. That is what the survey actually says, really speaking. But more and more things are all going to be there. I see the future of the profession is going to be more of the practice rather than the employment. That is going to be the case. But with this background, only thing is, what it's little bit pains to me is, I'm seeing, as Trapal said, 30 plus ROCs across the countries, and everybody is looking into it meticulously, going through the compliance, regulations, etc. and other thing and all. Every day, somehow or other, I have a good reading habit. I happen to see at least about 6 to 8 orders in a day. When I say the 6, 8 orders in a day, I am greatly pained. Are we living up to the expected level of promoting governance and ensuring the compliance? This is the question very often comes to my mind. It is not that people say I'm keeping on writing the article, etc. The whole idea of writing the article to bring to the notice of the profession what can go wrong, what is the precaution we can take so that we can raise the level of governance, we can ensure the absolute compliance. That is the whole purpose which I thought I will share with you. So with this background, what I will do is I will actually start my presentations. In fact, one more thing is that I am deeply delighted to note today more and more people's urge of learning is actually coming through. I see more participation coming from professional. That too also younger professionals, they are actually coming forward because I'm actually keeping, addressing the various young professionals who are qualified in the CLDP program and either PMQ program and other things. And all I see there are more urge of learning, knowing the things are there. But Tirupal puts it very clearly. What is their understanding the concept, the definition? That is very, very important. There, I think somehow we are actually missing it. Because I've seen the orders. What happens is, as the Tirupal court said, 62.3, there was a complaint which was required under 62.3. Somehow other the company secretary was there, he had complained with the 62.1c. And when the case actually came up, he argued 62.1c requirement was much more disclosure than what is required under 62C, 62C, 62.3. So I have done much more than the complaints of what it is actually called for. In the light of that, this case should be dropped. But people said nothing doing. What is expected is a specific complaint which are actually expected from you, which you have actually failed to do it. So specific complaints is required to be done. That is what it has happened. The ROC has passed the necessary orders. But the company still felt, no, the ROC has done a wrong thing. I will go and appeal, I will appeal to the RD. He went to the RD. Now you see, regulator thinking will be the same, whether it is ROC, ROD, they are guided by the rule book. They are going by the Companies Act, which is in their hand. That is the Bible. Even it is the Bible for us also. He also said there is nothing wrong in ROC's order. It is absolutely, I hereby confirm the order. So this is what it happens. So what happens is the interpretation, understanding the thing that we have been addressing in n number of seminars. Please go through the definition section, understood them. For example, DR12 filing. DR12 filing, okay, it's all right. DR12 filing is required to be done whenever people leave, whenever people join, whatever it is very simple. But when it comes to director, what is the section? Section 168 is applicable. But when it comes to KMP, is it 168 is applicable? It is no relevance at all. It is actually section 170 is applicable. Although the penalizing section will be the same for both. I think section 172, that will be the same, but the interpretation is something different actually. Because what happened upon the resignation of the director, we find the resignation of the director under section 168. But whereas we are supposed to maintain the register and records or all the KMPs with their interest, etc. and other thing and all. So whenever any changes taking place, in such a time, DR12 is again to be intimated according to them. It is nothing but a written filing under DR2. So this difference is actually make the difference in understanding the interpretation of the law. That is what I just wanted to add before I start presenting it. Let me start presenting. Let me start sharing the screen. I hope the screen is visible to you.
Yes.
Yes.
Okay. So this is the topic as put analysis of selected adjudication order passed by the ROC. Of course, I'll be also taking a few selected orders from the SEBI also as well, because the listed companies are actually regulated by the SEBI. They also actually initiate the action, which I will take up at the end actually in addition to whatever we are talking about the ROC. Now coming to the starting point, let me also start with the quote actually. There is nothing permanent except the change. Nothing ensures but change. Because every day we see the regulatory changes, every day we see the amendments, every day things are going, as Tirupal puts it, the new company's amendment is going to be on the future. The change is going to be there. Unless we adopt the change, unless we get ourselves repositioned to the changes, There is nothing. We have to actually adopt the change. That is one thing. So always we have to be, on our toes and keeping the things updation, knowing it. That is what it is actually called for to start with. When you come to the company secretaries, as you are all aware, I don't have to repeat because everybody is aware, there are two sets of company secretaries. One is actually working with the company 9 to 5:30, bound to the company, rendering a services to a particular company. Second is actually a practicing company secretary who actually cater on an assignment basis as and when it is required, servicing a number of companies. That is one thing. But when the employee company secretary is there, the complex of the business is too much because there is a complex business environment he is going to work. He has to work with the senior management. He has to work with the board of directors. He has to work with the independent non-executive, executive directors. He has to cater to the regulator. And he has to also act as a compliance officer. He has to actually handle the investor. All those things are, he fold is something like 360-degree around. That is what his goal is there. But in all those said and done, he has to ensure the smooth functioning of an organization, ensuring absolute compliance and holding the statutory requirements, especially maintaining the necessary records, filing the forms, conducting the meeting. All those things has to be there. And above that, again, as you are aware, there is a stakeholders committee which is actually there. So in which case he has to also facilitate the shareholders relationship. Of course, stakeholders comes, but prima facie shareholders who actually have various, compliance, the redressal mechanism puts in place and all those things which are actually. And above all, as you are aware, the directors are looking forward the company secretary. So he need to become a strategic advisor. I remember the wording our Sudhagar used to say actually. The role of the company secretary is that of the charioteer to the board, like in Mahabharata. What Krishna is actually acted as a charioteer to the Arjuna, and he was actually rendering various advices from time to time. That sort of the role the company secretary is actually playing. That is one thing. But coming to the practicing company secretary, yes, because the practice, as I said earlier, it is increasing. More and more demand is happening in the specialized area, etc., and other thing and all. So there are a lot of areas there, right from certification, right from specialized services, handling the IPOs, handling the FEMA-related issue, all the things which are actually there. And above all, we have been recognized as a secretarial auditor in par with the statutory auditors. Because if you know, the SEBI has actually came out with the regulations recognizing secretarial auditor appointment exactly like in a statutory auditor, treatment exactly like a statutory auditor. So 5 years at a time, 2 terms, all the things which has actually come, that means more recognition is actually coming from the public companies. Of course, the days are not far away. This will get harmonized with the Companies Act as well. Now the amendment and the other things are all in process. So probably we will see the same thing will be applicable for the unlisted companies as well. That is what I see in the future. So with this, what happens is PCS, if we talk about it, he is rendering a lot of services. I know Dipti. Dipti is running a very big organization, running around closer to 200 people across, maintaining 20 plus branches across the country. What is we have seen many people who are there, the senior partners and I think who have given a presentation very well in the different areas. That itself will give an idea. What are the things? Right from promotions, right from incorporation, formation of the company, right from various activities which are involved in the company, even representing the matters with the various regulators, whether it's the ROC or RD or NCLT or SEBI or SAT, etc. and other things and all. And whenever any restructuring, demerger, merger, amalgamation, comes place, etc., all those cases which are there. Above all, secretarial audit, which has been there, which has come for the first time in the 2013 Act. And again, after the secretarial audit has come, after the 2013 Act has come, the secretarial standard 1 and 2 concerning with the board of directors and board meetings and as well as the AG general meetings, that standard is actually there. The standard is nothing but supplementing the Companies Act itself. That is, the better way of doing it, harmonized way of doing it and all this. Even I am pained to see there are a lot of non-compliances which are actually coming. We claim to be, we are the core, master in our subject. But the fundamental things of conducting the board meeting, conducting the annual general meeting, other meetings, etc., and all the things, there are a lot of things which are actually coming up, which really we have to, straighten our belt. That is what it's looking like that. Above all, certification, signing, all the things are there about our profession. It is only to give an idea about our profession. But one thing is that our profession has traveled a very long way. If you look back the history, 1980, I've seen it. Those days, company secretary means people will show, oh, secretary. Oh, that means only ladies are supposed to be a secretary. Huh? That used to be the case because company secretary concept which got popularized only late 90s. Although 80, the act has come and other thing and all, initially it was not that popular. It has taken a little time actually. So ultimately it has come. But now if you look at the globally, the company secretary profession is changing drastically. The various institutes at the global level, they all changed, either charter secretary or a company secretary institute to the governance institute. That's what they have changed. Because when I registered for the UK company secretary examination, the institute name was actually the Chartered Secretaries and Administrator of UK. But today they have changed the Governance Institute of UK. That is what it has happened. Not only that, they have also now started awarding what you call, instead of Chartered Secretary qualification, they are actually now awarding what you call governance professional. As per the UK institute, you are free to use either the Chartered Secretary or governance professional, whatever you want to use it. That is what it is. There in UK, it is the same case with other countries like in New Zealand, Hong Kong, Australia, and other places also. All said and done, our role, if you ask me, what is your role? Compliance. What is your second role? Again, compliance. Because absolute compliance. When you say absolute compliance, what happens is I'm not talking ticking the box or the compliance seems to have been done. It happens. In reality, if we talk about it, I can say also, because husband and wife companies, I call it the private company where it is a very closely held, very few people are there actually. So what happens is, okay, this is done, this is done, secretary, take a meeting, banado. All the things are there. So that means what happened, we are talking about a paper meeting and the paper creating the documents. Ultimately, it appears the compliance seem to have done actually, which should not be the case actually, that we should actually have. So really speaking, you'll have to take a lot of pains whenever the company secretary is there. There should be, a proper checklist. There should be a maker-checker system and correctness, understanding the things as Tirupal puts it initially. And we should create a culture of, doing the things first time right. That is the culture we need to create. That is what I aim to actually. To be very frank with you, you may ask also, sir, you are talking all this thing. What about you? Have you done anything? You may ask this question actually. I am really proud to answer these questions. When I started the career, let me tell you one thing, I never planned to be a company secretary. I was hardcore accountant. I was actually heading a controller of accounts. Some other, the company went into public. They wanted to have a qualified company secretary. Those days, especially in the foreign company, the headcounts, which matters actually, they don't want to increase the headcount unnecessarily. So they broken their head. They told me, no, you are a qualified company secretary. You be the company secretary in addition to the what you call controller of accounts. You are controller of accounts and company secretary. That is how I become a company secretary. But the moment I took over as the company secretary, I realized the enormous amount of the job which are involved, especially with the listed companies. Today, I would say with the digitalization, with only 2 stock exchanges, the compliance is actually much better. But those days when I took the compliances, it was not that easy because those days we were working with the various regional stock exchanges. Our company had the registrar office at Pune. We are registered with the Pune Stock Exchange. Our company had actually the business operation in Madras. We are registered with the Madras Stock Exchange. Our company had operations in Calcutta. We are registered at Calcutta Stock Exchange. We are actually registered with the National Stock Exchange. All the things were actually there. It was complying with each of the stock exchanges, the thinking being different and all. When I go to one of the stock exchanges, have you got the approval from your main board stock exchanges, Pune? You please bring that, then we will give you the approval. This sort of things were actually happening. So much things. But anyway, today things are much, much better. Things are becoming very easy. Things are becoming digital. I think we'll have to equip to that. That is what I would like to say actually. Another thing is there, I also used to always talk going beyond regulations. If you ask me going beyond regulations, giving more than what is expected, that is what technically going beyond regulations. In my company secretary career, I am actually proud to share with you, way back in 2006 and 7, we were actually associated with a parent company at the UK. We picked up a world best practices from the UK combined code actually, because I happened to visit to the UK. I spent some time and I picked up those things. When I came, I discussed with my board. Way back in 2007 itself, much before 2013 Act has come, much before LODR regulation has brought in the year 2014, our company that time introduced what you call a vigil mechanism, whistleblower policy, and code of conduct and ethics across the company to all. And again, we have actually put in place dissemination of information to the marketplace. All these policies we have brought in, we have actually published these policies in a better transparent disclosure things in our annual report. So this is what I actually call it. Not only that, even we have started doing CSR. We have formulated the CSR policy, which also we have actually got published way back in 2005, 6 and 7. That is what we have done actually. I am really proud. Maybe many of you people will be maybe knowing also. I was actually a first second world best company secretary gotten recognition from the UK Institute way back in the year 2007 actually. That is my achievement, what I have done. If you ask me, sir, what about your practice in corporate governance and other things and all those things, if you ask me, I can proudly say that. So that is why I'm talking so much about the compliance, so much about the governance, raising the level of the governance, all those things which I'm actually talking about. And not only that, I also happen to train almost more than about 25 people in our organization giving a training. There are a lot of people who are really appreciating it today. And they are actually meeting me, especially, Guru Purnima Day and other things are also. So we have traveled in a very, very long way and we'll have to still go. But only thing is, we'll have to take utmost care and we'll have to ensure the absolute compliance. Now, coming to company secretary, increasingly, Tripal would know actually, the expectations of the ROC and RD from this profession is actually much more. They expect we need to be more careful. We need to do the right thing. We need to ensure the compliance. That is the expectations. In fact, one of the case which is actually there from southern part of the country, regional director of South, in Madras fertilizer case, if you actually go through the case, this is again, the violation cropping up in SS2 non-compliance. The gift were distributed at the annual general meeting. This is one of the public sector undertaking. That is what it is. Initially, ROC levied penalty upon the company and managing director, full-time director, but he has not taken any action against the company secretary, although company secretary was there actually. 35,000 rupees penalty has been levied. Somehow the company felt, no, this is, too much because, we have not done anything wrong. If the people would have come for the meeting, we would have provided, refreshment, this, etc. and all these things, since it was an online meeting. So to compensate that, we actually provided the gift. There is nothing wrong we have done. So we need to actually appeal this. They went in appeal. When they went in the appeal, what happened was drastic thing has happened. Immediately he said, the RD, sorry, it is the duty of the company secretary to ensure the compliances. He has to comply with the secretarial standard. The matter came from there. because Tirupal will add to this actually, if by taking the regulations. Company secretary has to ensure the compliance of secretarial standards. Yeah, Tirupal, please.
Yeah. See, yes, sir. See, if you look at the section 205, that is the duties of the company secretary. In fact, if 1956 Act, you don't find the written duties under the statute. Whereas 2013 Act, it is written clearly what are the duties of the company secretaries to be performed by the company secretary of the company. If you look at the 205 subsection 1 and the B, in the B it is written to ensure the secretarial standards issued by the ICSI from time to time. That is the language is used. The word is to ensure the compliance. So from where this particular Madras Fertilizers Company Limited, when they went on appeal, the RD saw this particular provision differently, altogether different, saying that the SS1 or SS2 non-compliance, it is not the duty of the board. They say it is a duty of the company secretary who is there in the company as a company secretary, and it is his own institute has issued these guidelines, that is secretarial standards, and he is the man is supposed to ensure those SS1 or SS2 while performing his duties. So the distribution of gift, if you see, SS2 prohibits the distribution of gift at the general meetings as per our own SS2. Since the SS2 was violated, though it was a government company, but it is generally a practice. No, sometime it used to be there. Now ROC people are taking very serious. You should not have distributed because it is a government, but the shareholders' money. Though you are giving back to shareholders by way of gift, but that is not officially allowed to give it. So they said clearly the company secretary has violated his duty. He is not, ensured, he has not ensured the compliance of SS2. So accordingly, instead of penalizing the MD and other whole-time director, we will penalize only company secretary. So the order passed by the RD was amended by the order passed by the ROC was amended by the RD. Say conformed only to the non-compliance to the company secretary alone, and the other the order passed against the MD and the company and the I think this one whole-time director, they are set aside. So here the company secretary alone paid the penalty for this. So that is the see how they are going fine minute level of the compliance and ensuring that how you are compliant or not. So one should be very clear about. I don't know how many of you read the 205 subsection 1B, the word ensuring. If you see the subsection 1, it says reporting. Subsection 1A says reporting, whereas subsection 1B says ensuring the compliance. So reporting of the compliance of Companies Act and the other applicable law, the duty is only to report. Whereas when it comes to the SS1 and SS2, one should ensure, the company secretary in employment should ensure the compliance. This is my submission.
Thanks a lot, Trupal. In fact, as you rightly said, the order itself says company secretary alone will be held responsible for the mistake committed. That is what it is very clearly said in the order itself. RDS very categorically mentioned. Not only that, he has gone little beyond. He says when a company secretary is appointed, the managing director and the whole-time director expected that the company secretary would take care of the compliances with the standard and not intervene in these matters. Very clearly, they are told, as you rightly said it. This is what it is there. So really speaking, we are talking company secretary as the KMP, we are talking his officer in default, all those things which are there, which came out very, very clearly in this, saying that the company secretary alone and he is alone responsible for these compliances. That is what it is there. So ROC has told it is only the company secretary, not others. As he rightly says, yes, the order has been set aside against company and other directors. It was only the company secretary. Then coming to the role of the secretarial auditor, although we call it a practicing company secretary, it is a secretarial auditor because Now the new law is recognizing it. The amendment which is actually proposed now is actually rewording the PCS into secretarial auditor and other thing and all which are there. It's a very popular case in Sun Pharmaceutical Industries. This is again the ROC order. What has happened was in this particular case, the related party transaction disclosure has not been made. It is brought out in the secretarial audit. So when the ROC actually started asking the company secretarial auditor, he said, no, I have taken the support of the auditor certificate, which is actually not saying anything in all. I thought everything is okay, so I have not got to the detail. I taken for granted nothing. So that is why the audit. The ROC actually gone into the detail, in a greater detail, what he has actually done. He actually said, all right, you can actually refer, there's no problem. But the problem is, see the guidelines issued by your own institute. If you see your own institute guideline, it says you are supposed to provide an unbiased opinion on the complaint status independently applying your mind after carrying out the necessary audit. Very clearly he has said. So he has to set again the word ensure. If you see the ROC order, he also uses the word ensure only. The secretarial auditor is expected to ensure that the activities of the client company are in accordance with the applicable procedure and supporting evidence maintained by the company was genuine. So this is what he said. He is not talking about the statutory auditor relying upon another thing and all. Company documents evidence is actually required to be examined. That's what very clearly says. Not only that, he has verbatim produced the guidance note of the institute, which is actually issued on that, really speaking, says what are the various areas you are supposed to go. The first item is the related party transactions. Then he spells out various other areas. I have just highlighted with the red colors. What are the things he's actually supposed to see? This is actually in our guidance note only. We have been talking in a number of forums also. The guidance note has been issued by, brought out by the eminent people applying their mind, which is actually very useful to each one of us, which is what it is required to be done. So not only that, the order says, has he actually worked with the checklist? Has he reviewed the related party transaction? Has he actually gone through independently, applied his mind? This is what it has actually happened, he brought out. So ultimately in the end, what happens is, because he has failed to do the function, 2 lakh rupees has been, penalty has been levied in this case. Same thing has happened in SR Shipping Corporation case also, where the ROC Ahmedabad, he actually said, because here also the central auditor is actually not reported regarding, minutes book of the board meeting and the audit committee meeting as per the requirement, and he has not reported the complaints of section 186. All those things he has not done. And here also again, something around 1.5 lakh rupees penalty has been levied. Sorry, 2 lakhs here also. 2 lakh rupees penalty has been levied in this particular case also. This is what it has happened. So that we see the way in which regulators are looking at the company secretary, how they are looking, how the company secretary actually should discharge and function. That is what we said. So that means why the things are going wrong. That is the next question comes actually. Where we are going wrong. Whether it's the practicing company secretary or it's the employment company secretary, where we are actually going wrong. That is the question actually comes. I've seen actually what happened, many of the orders passed in the past, it actually shows for the very, very trivial nature, which actually should not have been taken. Agenda with the inadequate documents, disclosure not taken on record. All the way the directors, they give the ABP to forms, which is actually not taken, it is not getting recorded. That is the thing. Again, when we are writing the minutes and meeting, etc., our guidance note also says even the standard also, date, place, everything need to be there, which is actually missing. On unnumbered meetings, blank pages not scored out. Last page, not actually full signature. It is only initial. Minutes itself is not signed. Unsigned minutes has been produced for the inspection. Date of entry is not made actually. There's a requirement is there. Whenever the minutes are made, draft minutes has to be circulated within 15 days. And you'll have to wait for the 7 days for the directors to come back. And if it is not there, then the minutes are taken for granted, it is actually approved. And within 30 days, there should be an entry in the minutes book. Invariably, that is not happening. So many company secretaries, they are actually doing it. When they are writing the minutes, if you actually goes in the last page of the minutes prepared, minutes dropped, circulated, minutes approved, minutes entered. It is actually put up there actually very clearly. Many people are doing it. Drupal will actually elaborate on this actually because he's one of the senior most person. Yes.
Yeah, this is the issue is about minutes preparation. The challenge is that we will not be there when the minutes were prepared, when they were filed, and all. Only the date that is mentioned only should confirm it. However, if you go through the flow of the events, no, like right beginning, the notice should have been circulated, and then after that, if there is any item that additional clarification is sought, that again should be provided with the company to each and every director of that particular board meeting. And after that, like certain agendas as per listing regulation, like 2 days in advance only can circulate because of the price sensitive information, all those things. So here maximum now you see this all the flow, you can track it. You can track it through the like mail system, or some companies are following through the some internal system, internal like you have WhatsApp group, no, similar to that some group. Anything, any electronic delivery of the notice to the director is permitted. Similarly, if you go through the minutes, draft minutes circulation to the board members, within 15 days, again 7 days time is given to the director to respond, and within 30 days from the date of meeting, you will get everything, every feedback and entry. Here, most of the companies are preparing minutes only in the physical mode. Even you go to the big corporates, listed mega group companies also are still preparing only physical minutes. Very few companies are preparing the electronic minutes. So if the minutes are prepared electronically, this entry date no need not be put it, because if the electronically the data is entered, it has a timestamp in it. So there is no problem with respect to the electronic minutes being maintained, and you will have a timestamp. Whereas if the minutes are prepared physically, they need to certainly enter the date when these minutes are entered into the register of minutes. So that date is mandatory. Like sir was telling, at the end of the minutes, you will get like 3, 4 dates will be there. One is when the minutes were entered into the register. The next one, when the chairman has signed. Then when the signed minutes were circulated to the every director, because now as per the SS1, signed minutes also are to be circulated to the director participated for the each and every meeting. So these are the dates are very crucial. If any violation of these dates, it will lead to the non-compliance. So these things can happen only when things are done then and then are the timely. If you are doing something backdated, anything like hanky panky thing, if you are doing, then you will get stuck like this. Probably in this case, where in this particular order was decided, no, would have not been prepared minutes as per the time manner. So they would have stuck here and there. That would be the reason. But if you ensure the minutes are prepared like any other document that you prepare timely, and you will not be facing these kind of issues. And similarly, when you go to the secretarial audit, no, if you are a secretarial audit, if you do kind of a concurrent audit, like a quarterly audit, and then if you are able to do that concurrent audit quarterly, you will be able to find these issues, and then you can sort it out, and you can make the company to be a full compliance. You ensure the company is in compliant. If there are any issues within the quarter, no, you will be able to tell them, and then they will rectify it, and they will ensure the compliance. Only if you do at the last moment, maybe after end of the financial year, like cases listed companies, no, you are supposed to finish your audit by 60th day from the end of the financial year. So if you start your secretarial audit at the year end, it will be very difficult to look into the each and every aspect of the secretarial audit. Instead, you can suggest, you can advise your client that you will do a quarterly audit. You can even charge them quarterly also. We are doing for 2, 3 companies, and we do most of them, especially for listed companies, we do the quarterly audit. For some unlisted companies, we do the 6 months audit. So I suggest to maybe seniors or whoever is there, or even the employee company secretary, to you can insist the PCS form to come to quarterly and provide you, inputs on the document that they review, so that you will rectify it. So I feel the quarterly, regular, then and then, audit, what is that period, audit frequency will make them, to ensure proper compliance.
Thank you,
Thank you,
Trupal.
sir.
As you rightly put the point, any non-compliance inadvertently or mistakenly happen, that can be set right if it is addressed periodically instead of addressing it at the end of the year. This is a very good suggestion. In fact, we have been doing that actually. In fact, not only that, we have been doing it in a secretarial profession as well as the finance profession. Even our auditor used to come, he has to go through and all the things. Sometimes, some TDS form is not filed and other things, he used to immediately bring out. We used to rectify it. That used to be the case. The one question has come actually. Here the Shruti is asking, do we need to add page numbers in the minutes before sending signed minutes in the directors in view of the circulation within 15 days of signing?
Yeah, see, I will tell you. See, this is in fact, if you look at the signed minute circulation to the directors.
No, she's talking about the draft minute circulation, I think.
No, she's talking signed minutes before
Okay.
signing.
Okay.
Before sending signed minutes. Yeah. So what I'm trying to tell you here, this is the invention of the SS1 to protect the director who has left the company. Tomorrow, if there is a case against the particular director and it goes to the court, director has to produce this. He has made a disclosure in the minutes. Like example, being a related party, he is supposed to make a disclosure. That is one disclosure requirement. Similarly, if he doesn't want to participate in the discussion, he doesn't want to be there in discussion or anything, he wants to give his not affirmative right, he wants to vote against it, and he has to ensure those things are recorded in the minutes, so that he will be protected. If you look at the section 149 subsection 12, it says clearly the independent director and the non-executive directors will be valid, means their particular will be questioned or will be liable only if they are given consent, conveyance, or they have not acted diligently. See the diligently, whether you have acted, whether you have given your consent, whether you have not given consent. For the directors who are just independent directors, not executive directors, the medium is only the minutes. There is no other communication that you can do it, and which will be permanent, like evidence. Okay, permanent evidence. Now, such evident document, which is going to be in the hands of the board, and also the copy with the respect to director. And now you are not put the numbers. Think of it, tomorrow is trying to do the company with some different book and different numbers they are putting, and director whatever he will show and produce before the court will not be the same document. You got my point. So I feel it should be a kind of as it is, whatever it is, circulated to the signed minutes, you should have intact as it is. It tomorrow, if it goes to the court of law, director also will be able to say, yes, this is the one minutes I have got it. You should not say these are not the minutes which I got it. I feel it is better to put the page numbers, because it is not what we need to understand. Minutes are like a running book. Like you read any novel, minutes are running book. You will be knowing that what is the next number. So I feel I understood as per SS1 compliance, moment you print and finalize the minutes, get them signed, by that time minutes should be all right in all respects, including page numbers. Those minutes only can be circulated to the director for his record. Why we are giving minutes, signed minutes to the director is only for his record. You may not bind out, see the binding of the minutes is not mandatory immediately. You can bind after 3 years once, 4 years once, as the board decides. But having intact with all the compliance of the SS1 is a must. Only that copies can be circulated to the director. This is my understanding.
Absolutely, you are right actually. In fact, whenever the draft minutes are actually circulated, once it is get approved, what we do is we actually print the minutes and we page number also, and then we enter the minutes book. That is the thing. Once it is signed, along with the page number only, it is circulated. As Krishnan is actually writing here, I think these are all the basic things, bread and butter, which a practicing CS or CS in the industry has to take care being responsible in compliance. Absolutely, I agree with you. That is what I'm also saying. You are reflecting the same thing. What are the procedural compliances for resolution by circulation? Resolution by circulation, there are items which are
Sir,
specified, which can, yeah. Yes,
sir, we
please.
have detailed standard, it is already there in the SS1 para. It is clearly indicated what is the procedure that you need to follow, like giving 7 days notice and then waiting for the, majority. Even if you are not able to get one third people, means directors can say this item can be conducted at the meeting, then the item cannot be passed on circular resolution. There is a detailed process. Compliance is already there in SS1. I think one can refer that SS1 clearly, apart from section that is dealing with the circular resolutions.
Arvinda is writing, when a company is a family control, sending a draft to 4 minutes to all the directors seems to be redundant as it bears no relevance.
Yeah, Mr. Aravindan, I think, can you give a guarantee that family doesn't break? Tomorrow, if both brothers or even wife and husband, technically the SS is there to protect the, what is that I can say, oppression mismanagement cases. If you follow end to end SS1 and SS2, you don't find the oppression mismanagement cases. Look at the oppression mismanagement cases across India. The first allegation of the director or the shareholder is notice is not served. We are deprived of the notice. It may be a board meeting, it may be shareholders meeting. They say we are kept in dark. What is happening at the company level, we are not aware of it. And raised by whom? Either wife or husband or brother. So I think the notion, the notion concept of family control should come out. We should be away. We should not think about it. End of the day, whether it is I will give an example. Whether it's a wife and husband or whatever it is, if a doctor is doing the operation, I think he should make utmost care. He should, for him, he's a patient. Doesn't matter whether son or whatever it is. So I like that company secretary when he's performing his duty. You can't decide something is relevant or redundant and all. Do you think that the person or the team or the MCA or the ministry or even our own institute who is behind the SS1 think they are not aware of this family run concern? Or they are not aware of the disputes that are being there before the NCLTs across India, where are only family members are the disputers, or even wife and husband. One should be very clear. You should see the essence of this particular thing. Just now I explained you why we need to share the signed minutes to the director. I got a case where wife and husband, they are in the divorce. They are unable to produce. Is not able to produce the document of a meeting where wife is alleging that this meeting has taken place like that. So I feel let us do our job as a professional. Don't take any emotion of the company, or rather, I can say emotion of the industry. Don't do that. That's not correct, Pastor. That understanding itself is not correct.
I was informed by the company secretary that the online meeting recording does not have any time mapping. Therefore, although the meeting actually started late and continued for more than 20 minutes, the recording is only for 10 minutes.
Then you should deny as if it is not a meeting. That's all. What is recorded in the 10 minutes, probably you can record it. That's all. What is not recorded, sir, something is evidence, something you have evident. Then how you say something else was also discussed in the meeting? Can you say? You can't, in fact, you can't insert anything. If the meeting is online, it is recorded perfectly. You can't insert anything beyond what is recorded. Can you insert or can you remove it anything?
How to maintain the digital minutes? Can you please elaborate on how to get a timestamp and all? Are there any software we purchase for it? Please tell us there is no clarity of the market practices maintaining these also for statutory registers.
Yeah, see, it is simple. I will tell you. If you go to the, like, you are an accountant, you are making an entry in the SAP software. It takes care everything, stamping and all those things. No, when you make the entries like some X entry, Y entry you are making, and it will take when you pause that entry, it will not allow you to do anything hanky-panky, backdated. All those things are not there. So similarly, containing this maintaining the digital minutes, no, one should have the proper software which cannot be rectified, which cannot be even tamper proof. Like now we have in accounting standard, what is that called? This is audit trail. You know, more comprehensive, I think till date I'm not finding any software having allowing with tamper free minutes maintenance, and or it is not there. Probably you need to develop it on your own, or maybe some private companies or some private organization would be making it to have this kind of maintenance. But till date I'm not finding any digitally maintained company, and all are maintained physical minutes. Because I'll tell you one problem is there with the digital, why people are worried of the digital minutes. See, it is just a fraction of second. You will be the minutes, if they are leaked, can reach whole world. If it is a physical minute, electronic minute or digital minutes. That is the reason big corporate, they are not ready to maintain any minutes digitally. Still, if you insist, probably you have to see any good software is available, which will be transfer, tamper free, all those stuff. Otherwise, I'm not finding a good software which you will do all those things.
The other observation is that while the presence of the internal auditor in the audit committee meeting is actually recorded as equity, and the absence of the internal auditor is stated in the minutes as internal audit report was discussed and noted. Yeah, that is the right thing. If his presence is presence should be put, presence is not there, yes, it should be recorded. That is perfectly right.
In fact, sir, similar to this, if you see the AGM minutes or general meeting minutes, as per 146, the presence of auditor is must. Or he should send his person or associate who is also a chartered accountant, or he should seek the exemption from the meeting. We have found some minutes, even recently, some notices from the ROC. In your minutes at EGM or AGM, there is no mention about the whether auditor was there or auditor was given on request the leave of absence. All those things were not there. And for that, auditor was questioned. In fact, our ROC, I think Bangalore ROC has served a notice on auditor to prove it. Whether you have received any notice from the company, first of all, please prove it. Next question, have you sought any exemption from the meeting? Because I found from particular company minutes where you are a statutory auditor, wherein your presence was not shown in the minutes. So then the finally audit company was able to prove that the auditor was served the notice as per 101 for each and every general meeting. However, auditor did not seek the exemption, and he was unable to provide any documentary evidence that he sought the exemption from the company. And company also simply ignored it as if he was not there and they didn't record in the minutes. And the minutes of the company made the auditor to go for a compounding. So he filed a compounding application under section 146 for not attending the meeting and not seeking the exemption.
There is also the decided case where the company and the company secretary and KMP, they were actually penalized, not ensuring the attendance of the statutory auditor in the meeting. That is one. And second thing is, as you rightly said, I think when I talk to many people, by and large, some of the people are actually under the wrong impression. See, thinking the notice is to be given to the statutory auditor only for the annual general meeting, not for the other meeting. But whereas he has to be served notice for all the general meetings. That is the
Section
wording which is
146 uses the word general meetings. It doesn't use the word annual general meeting.
correct. That is the thing.
All meetings, the whole idea of this particular 146 is to ensure the decision makers. So you have been appointed by the shareholders. You are the person to report the shareholder. Each decision that is made, see, the shareholders can make decisions only through the meetings. And even they are making decisions, if you witness, you know the essence, why the decisions are made, like why this is passed, why this resolution was passed, why this amendment is happening, why this. So you being an auditor, expected to witness that particular discussion. and then accordingly you do your audit. Means it is like a spirit and letter and spirit. You should do compliance while being an auditor of the company. That is the whole idea. So you should know how decisions are made by the shareholders.
Section 2051 says that the CEO shall report to the board of directors the compliance of all the laws applicable for the company. Now, he may not be strictly involved in compliance of all the laws. So, is he responsible for the compliance of all the laws? See, if you see very clearly, as you rightly put it here, he has to ensure the compliances under the Companies Act. That is very clear. If he is a listed company under the LODR regulation, it is his job, his duty, he has to ensure. But rest of the other things, he has to actually ensure it is compliant. That is it. He himself is not required to comply, but he has to see that compliance is done. That is his role. In which case, he will not be held responsible in case of the penal proceedings, etc., and other thing and all. But at the same time, he has to actually see, he has brought to the notice of the people from time to time what are the complaints are required. If he fail to do that, he will be taken for the task. That is what, yeah.
Yes, sir is right. If you look at, I think Mr. Abhinav has written, Bharadwaj has written correctly. The 1A I was telling, though it says that functions of company secretary shall include to report the board about the word that you need to pay attention about the compliance with the provisions of this act, the rules made thereunder, and the other laws applicable. So it is about the compliance. So, as a company secretary, your duty is to say, share the status of compliance or place the status of compliance before the board. That means you are like via media. You should ensure that the compliance status has been placed before the board. It may be like example one tell you, there is yours is a mining company and there is an environmental clearance is required to be obtained. However, environment clearance was not obtained and still the mining is on. Can you stop the mining? Technically, it may not be your position. It means you will not be able to stop the mining. However, you will be able to bring that particular thing before the board, saying that, sir, we have not got the environment clearance. We should stop at this stage, this mining. It will become an illegal if you start the mining without having the proper license. And if you don't bring this particular non-compliance status before the board, even though you don't ensure it, you can't ensure every compliance under the laws of the land. See, if you look at, I have gone one case like one sugar company, we found total 250 different rules and regulations are applicable to the particular company, like sugar company having power generation. See, as a company secretary, I will not be able to comply or ensure the compliance of all under 250 regulations. However, I will be able to generate a report. I should be having a system wherein I will be able to generate the report about all the 250 laws that are applicable to a particular industry and then place that particular status report before the board, because that is the duty of the company secretary. Once you are able to comply, once you are able to produce before the status, and subsection 2, I think sir somewhere it has written, somewhere in the slide it will come, and subsection 2 will save you. Please go through the, for all guys who are appearing before or attending the seminar, I request you to read thoroughly 205 subsection 2 also. It says clearly it's similar to the section 149 subsection 12 to the independent director and non-executive director. Here also for company secretary in-house, there is a saving provision that is available in subsection 2, which will be explained later. So it will save you. It will save you from the being a non-compliant or being a responsible person from that. But if you have not done your duty of reporting the status of compliance, then you will be held responsible.
I think let me run through this presentation because we are just in the beginning only. There are a lot of things up there which we'll discuss.
Yeah,
a lot
please,
of things
sir,
are
please.
there.
Yeah.
So let me run through it, then we'll take up the questions. So as I was discussing with you, the private limited company, these are the trivial things which are actually coming. According to me, the practicing people have to be little more, helpful to the private company people to ensure the compliances. They can actually advise them. That is where I say going beyond the regulation, telling them what is the thing, what is called for it. Whereas in case of the public companies, I am really surprised to see the wrong constitution of the committees. Disclosure is not taken on the directors on the board, and again, non-appointment of the internal auditor, non-appointment of the secretarial auditor, non-appointment of the independent director, ID's appointment without having the details in the data bank, non-appointment of the women director. These sort of the things which are there, which are all the fundamental issues. I think we should not miss out actually when we are talking our professionalism and things like that. That's what I feel, because these are all the basic things which we need to take care of it. And again, in addition to that, I also come across with various CSR violations. Again, the composition, the activity, non-transfer of funds in time, and again, related party transactions, non-approval from the audit committee. In one of the case, they've been getting the related party transaction, referring the resolution passed 5 years ago. Instead of taking the, ongoing approval or the omnibus approval, which is routine approval, they have not done that. That is what it has happened. And again, the statutory register. Statutory register is there, but it is not maintained, it is not updated. So those sort of the things which are actually there. Again, beneficial interest is not disclosed. Various non-filing which are actually there. These are all the things which are actually happening. And similarly, the reporting. Either the late reporting or the disclosure is incomplete. Board report does not disclose many things which are actually written out, missed out. Auditor's qualification is actually not addressed. Material subsidy details are not given. Material events are not disclosed. This is one of the complaints which is coming from the public listed companies in this under SEBI LODR regulation also. The material events are not reported. That is one of the things which keep on coming in every order if you see the public listed companies. Either it is not reported or it is late reported. That is one of the things which is actually. Similarly, dividend not transferred within 5 days. People think 5 working days. It is not 5 working days, within 5 days. We will have to work with it because Saturday, Sunday, weekend, holidays come, we will have to take care of it. That is one other thing. Separate bank account is not open. This is another issue which is actually happening. Funds are utilized before allotment is actually made. All the things which are actually happening in many companies, these are all the issues which I come across actually. So what is the solution? Solution is very simple. If the non-compliance is there, first of all, we should not allow the non-compliance to happen. That is the prima facie thing. That's what I said. Adopting the principles or doing the things first time right, that will actually help you. Work with the checklist, work with the maker checker. If it is required in the private companies, take advice of the professional. That is the one way, better way of doing it. Okay, it has happened, then we'll have to sort it out. How do we sort it out? Sort it out, yes. You can go for the continuation delay wherever is possible. Everything cannot be controlled. Suppose AGM is not conducted at the due date, even the extended date, that cannot be actually controlled and you cannot rectify it. It is gone actually. So wherever the continuation, late filing is possible, etc., intimation, all those things, you can go for the continuation. We can put up the thing, why it has happened, what has happened, seek the approval. You can still set right the complaints. Then again, the adjudication application, although the word is used suboto, as Tripal puts it in the beginning itself, it is not the actually suboto application. It is actually, we are actually intimating what has actually happened and we are actually willing to go for this. Then he issues the show cause notices. The procedural things follows. Show cause notices will come, will be given the opportunity, personal hearing will take place. Ultimately, adjudication order is passed. That is one thing. Here again, people thinking is like that. Okay, let them find out, let it come back, we will face it. Why to go? It's something like, why should we voluntarily go? That sort of the thinking is there. But the thing is, when it talking about the compliance, I think we should actually come forward, we should admit, we should go for it. That is the right way of actually doing it instead of waiting somebody to find out. Because if you actually admit it, we go yourself, the lenient view will be taken within the permissible limit. Wherever the fixed penalty is there, he cannot do anything. But wherever the range is given, not exceeding so much and other thing, and all the discretionary thing is given because it shows your jurians are coming forward and ensuring the compliance is though not in timely compliance, but the late compliance. So that will itself actually show that is one thing. Of course, the option is another thing is compounding. Compounding, as Trapal puts it, many things is getting deeper. The compounding will be there only rare cases where, fraudulent things and misappropriation, those things are all taking compounding. Otherwise, it is not the case. Whatever the compounding was to be there earlier, everything is actually transferred to the adjudication process. These are the mechanism by which we can actually sort out. When you talk about the continuation of delay is a process where, you have to actually go. Suppose you missed out the annual filing, MGT 7 is not done, AOC 4, 92, 137, all those things are missed out. Yes, we can actually file it extended time. So that is one thing. What you have to do is, there is a procedure is there. We have to seek the continuation of delay. Continuation of delay, we have to go to the Government of India actually. There is a form is actually there. You have to first get the government approval for the continuation of delay. For that, you have to actually conduct the board meeting, and then you have to take the necessary approval, authorize a director or company secretary or whoever it is, or authorize PCS to appear wherever it is required. Then you file a continuation of delay application, give the necessary document like a certified true copy of the board resolutions, and give the reasons why the delay has happened, what is that, and other thing and all. And then the indemnification petition is required. Then a memorandum of appearance, wherever you want to appear for the personal, those things to be provided, letter of authorization, all the things are all will come for. Once it goes, government will actually scrutinize. Then ultimately they will issue the personal hearing notice. Then in the hearing notice, they will hear from you whatever the things are there. Union is there, yes, necessary condemnation will be given. Once the condemnation actually given, then the condemnation order is required to be filed with the ROC in the form INC 28. Once you give that, then you will be permitted to file the late filing of the form. So company could file the respective documents, whatever it is, which is actually missed out. So that is how it is actually sorted out. While filing it, yes, INC 28, where you file the form, that SRN reference has to be given while filing the form. That is the requirement which is there in case of the condemnation delay. It can be done. In many cases, in the genuine cases, yes, condemnation of delay approval is actually given. It is the seal increasingly. If you really have a reason, that can be done. That is one way of sorting out. The second way of sorting out is adjudication. This is what the most common thing which is actually happening now. Normally, there are two things. One thing is that nowadays, increasingly, ROC on the online itself, he take the inspection. He actually goes through, and again, he actually inquire with the company. He calls for the documents, and then he finds out whatever it is, and then he issues the show cause notice. I have a reason to believe there is some non-compliance is taken place, etc. That is what it is. Or otherwise, the company himself, upon realizing it something has gone wrong, they can intimate to the ROC, again, which emanates, again, it is followed the show cause notice. Once the show cause notice comes, they will give you the time. Normally, they give you around 15 days time or something like that. Sometimes they give 30 days time also. But only thing is, yes, you can ask for the extension if it is required for. Some genuine cases that will be given. Once it is actually given, you provide the explanation, etc., and other thing and all. If the explanation is satisfied in the sense, for example, in case of the annual return and also the annual financial filing of the statements, there is a particular procedure is there. A circular has been issued by the MCA saying that, the moment within 30 days of the issue of the show cause notice, or even before the issue of the show cause notice, if the compliance is actually done, then no action will be taken. It's deemed to have been done. That is the case. Suppose the ROC issues the compliance, financial statements are not filed, or annual return is filed. So immediately upon the receipt of show cause notices, if we actually complied with the things, if we intimate to them, immediately, then the matter get actually closed. That is what it happens. Otherwise, you will give the hearing. Once the hearing is given, then you can represent the case, etc., other things and all. Normally, hearing also sufficient time is given. Nowadays, increasingly, the e-hearing is taking place because of the digitalizations. So once the hearing takes place, then after hearing from you, you will pass the necessary order. Once the necessary order is passed, then again compliance with the order which is required. Another thing is there, remember, whatever the penalty is actually levied, either on the director or the KMPs, they are all payable from out of their own pocket, out of their own source of income. The order also very categorically mentions this actually. That is one thing. You may be thinking there is a DNO insurance is there, money can be recovered from the DNO insurance. DNO insurance will actually pay all the litigation charges, legal charges, etc., everything will be paid. At no point of that time, any personal negligence penalty levied by the regulator will not be reimbursed by by the DNO children. That is one thing which you have to take care of. So definitely speaking, one has to be very careful because the money is going to go from their own pocket. It cannot be reimbursed by the company. That is one thing very clear. Of course, any order which is passed on the ROC, there is an appeal procedure is there. The appeal authority is actually RD. And there is a time limit is given. Within 60 days time, you can make an appeal. You can represent the case. So RD will hear it. So RD has got a different option, whether he can set aside the order, what has happened in the Madras fertilizer case, because his own reason he has set up it differently, or he can modify the order. Modification of the order will be based on the merit, because many a time what happens, financial difficulties, companies not able to make necessary profits or other things, unforeseen things, all those things. He can actually modify the order. That can be done. That is one thing. So here when the personal hearing is taking place, you are given the opportunity. And even if you are not able to produce certain thing, you can take adjournment also. You can make other submissions also. Those also can be done actually. Many times RD calls from the ROC the report. Even many times invariably ROC also present in the hearing. That is also seen actually. Of course, the compounding offences, as I said, this is a compounding offences actually very limited because now everything is actually decriminalized. But here, when you say compounding of the offences mean what? Compounding of offences mean in lieu of the fines, in view of the imprisonment, we are just converting in the monetary terms. That is what it is there. But only thing is, it says very clearly, not being an offence punishable with imprisonment only, or punishable with imprisonment and fine. The wording is very, very clear. If it is imprisonment, it cannot be fine. It cannot be compounded at all, actually. Okay. The wording is, if it is or, then yes, it can be done. But if it is and, it cannot be done. So it is very clearly says what is the offence which can be compounded, which cannot be compounded. And again, the maximum amount do not exceed 25 lakh rupees because it will be dealt with the regional director's level. If it is beyond 25 lakhs, then it has to go to the tribunal level. That is actually the authority which is actually given here. That is one thing. And another thing is that compounding can be done for a particular section. That you have to remember. Because a particular section of the Companies Act, this can be actually done. But only thing is, yes, punishable with the imprisonment only or with the imprisonment or also with the fine. These are all not compounded. That is very, very clear. And similarly, if the investigation is going on against the company, then you can't file the compounding application. And again, 3 years time limit they have actually put if the offence is committed by the company and within a period of 3 years, the same is actually repeated, it cannot be compounded. That is what it is there. When they say it is not the question of nature of the offence, it is actually the particular section. You have to remember that. These are all the restrictions which are there actually, the compounding. Again, the compounding will be more or less the similar things like adjudication. You have to have the board meeting. You have to actually have a necessary authority. You have to follow SOS1 procedure, giving the necessary notice, providing the documents, etc. Other thing and all. Then pass the resolutions, authorizing for filing the condition, compounding condition and delay, whatever it is and all. Then once the company prepare the compounding applications, then depending upon whether RD or NCLT, you have to file. You have to file the online. You have to also physically lodge the documents also with them. That is one thing. And again, in case of the compounding, we says the condition, we talk about the general one form, but in case of the NCLT, there's a specified forms are prescribed under the NCLT rule. That is what you have to do it. So application can be filed by any director, manager, CS. But whenever the manager or CS, if the director is there, D number is required. If the secretary is there, PAN number is required. If the other persons are there, expatriate people and other things, they may not have the PAN number, they'll have to use the passport. That is what it is there, etc. Or otherwise, you can authorize any of the KMPs if it is available in the company, or otherwise, you can take a practicing company secretaries as an authorized representative. That can be actually done. And another thing is that all these things will be handled either RD or NCLT. Personal hearing, you will have to give a reason and you will have to speak it. If it is genuine reasons, yes, it will be taken. If it is not, it will be otherwise. The order will be appropriately processed. Now let me come to the crux of the matter. Adjudication order, which is what's actually my heart, which I have been talking in the beginning. Let us look at some of the adjudication order which are actually coming. If you actually look at it, you see in case of the private limited company, what is happening? Apart from what we are talking about, the trivial orders. See here, what happens is, mostly these are all, husband and wife company, as I call it, really speaking. Very limited people. Professionals are not associated. Professionals are engaged as and when needed. So they really leak the legal requirements. There is no professional advice is actually available because they have to seek every time. That is what it is. So that is where I say the practicing company secretary proactively can play a very active role in educating these people and ensuring the compliance. So that is what I would actually say. Here, look at it. Delayed intimation of commencement certificate. Now the company is actually incorporated. Any practicing company secretary would have actually helped. Probably if you would have told him, look here, the commencement certificate requirement is there, it has to be filed within this particular time limit, the company would have actually not gone for that. Probably that is what I say, going beyond the regulation and intimating and educating the people. This is the case of the Bangalore ROC case, which is a very recent case actually, February 2026. It's a extreme power, India Private Limited. The delayed intimation of the commencement of the business. See the penalty which has actually come. Company 50,000 rupees, two of the director 2 lakh rupees, 2,50,000 rupees, which has happened. And similarly here, the specific provision. This is what I talked initially. 62.3 and 62.1C. This is what it has actually happened. So in this particular case, although I have complied with the 62.1C, it is more than adequate than the 62.3. That argument is not taken place because specific complaint was called for, which is actually not done. So in which case also company 1 lakh rupees and director and past director, this has been failed actually. This is what it has happened in this particular case. Here you see the failure to file the KYC in Form 3 KYC. This is the routine thing which is actually required to be filed every year. That is the thing. Here also the same thing is, I would say actually practicing company secretary would have definitely assisted. This would not have happened. It has happened in the Kanpur case. It's October 25, East Alpha Alliance Private Limited. Here what has happened, KYC of the directors in Form 3 of KYC not right. All the 3 directors. Each of the directors have been penalized 50,000 rupees each. Because it's a responsibility of the director, not the company. So that is what it has happened in this particular case.
Now, the proposed amendment for this KYC, they are going to make very serious, severe, and more impactful. If you don't file, now the KYC has been amended. No, it is 3 years once you need to do it. If there are any modifications like your address, email ID, mobile number, you need to file that to DR6 form, and then KYC will come only 3 years once. Now, in the proposed amendment, if the KYC is not done and your DIN number becomes deactivated, and what is the consequence? That MCA says you will vacate all offices. It becomes a vacation of directorship in all the places where you are a director. So KYC is going to be such serious, maybe once this proposed amendment is going to be there. Non-filing of KYC will lead the losing of all directorship. Vacation of office. They are going to insert this into section 167. They have made a provision, enough provision. So one should be very careful. So at least yearly once we will have a track of it, and there is a time frame. You will, mechanically will do April to so and so. Whereas in the case of this particular individual who has got, suppose this year 2016 he has got his DIN number, and his 3 years will be different when compared to someone 3 years. So it is very, very difficult to have the track of KYC filing henceforth.
And again here, financial side by the disqualified directors. This is what it has happened. Upon filing it, they found out the disqualified directors have signed. So straight away they said is a company has to ensure 1,50,000. In this particular case, what happened, although there were 2 directors were there who was actually signed, but by the time the case has actually come out, the director was expired. So there is no penalty in this case. Otherwise, directors were also equally responsible for the penalty. That is what it has happened. This is the case which was taken out by the Guwahati ROC. Again, this is a very recent case in the year February 2026 is the order. And a failure to pay the annual debenture interest. This is a very interesting case. In this case, what has happened is they have issued the debenture. The terms of the debenture says annual interest. Now the company argued, although we agreed annual interest, the payment is not required to be done annually, but it is accrued. It will be paid at the time of the maturity. That is the argument they have actually put forward. ROC tells very clearly, sorry, look at your terms very clearly. The moment you say annual interest payment means it is actually payable annually. That is what it has actually come out. So this case actually turned out to be like that. Again, the question is interpretation and correctly for following the terms and conditions of the agreed things with the debenture holder. That is what it has happened in this particular case. So company was penalized 2 lakh rupees, managing director, where they put the managing director who is responsible for the non-compliances. So 50,000, 2,50,000 rupees, which has happened in this particular case. Then here, non-filing of DAR toll after the director resignations. Company forgot to file only. That's all. Simple. Director is right. No filing is actually done. This is what has happened. So company has been penalized 3 lakh rupees. Two of the directors were there, 1 lakh rupees each. This is what it has actually happened. This is the another thing. Then again, in case of the CS resigned. It is again the case of the Chhattisgarh. They are not filed. But where the CS himself has complained to the ROC, even after 1.5 months or something, the form has been not filed. Then he took up the matter with the company. When he took up the matter with the company, then later company filed the delayed complaints. Actually, that is what it has happened. The law provides actually the non-compliances initially 50,000 rupees and 500 rupees per day for the period the non-compliance was there. Accordingly, they calculated. The company was penalized. Director 2 was penalized. Everything is penalized at 82,500 for the non-period of compliance. It is not happened. As I said, it is coming under section 170 subsection 2. There the director comes under section 168. This is what it is.
Now, sir, at least if you look at the 168, earlier it was the shell was there to file the DIR 11 by the director. Now they made it to May. So filing of the director resignation by the director himself is an optional now. However, a similar provision is not there for the KMP, like company secretary, CEO and CFO. These three people, they are left with no choice. That would be the case leading to this particular case, because now in the proposed amendment, a similar provision similar to the 168, they are going to provide option to the KMP, like company secretary, CEO, CFO, also to file similar to the form DI 11 and bring the notice of the ROC about their resignation. Moment you get the acknowledgement of your resignation, you will be able to file your own form and ROC will take action against the company. I think this is going to be very good move similar to the directors. So this may not be, there need not be fight. We don't need to fight with the company for filing the DIR 12 for that.
This is a very welcome move actually.
It's going to be there. Yeah.
Coming to the public company, let us look at. Coming to the company, the minimum member count is not maintained. The required number of members. This is what it has happened in this case.
Yeah, this minimum number count is there under section 3A of the new act. The new act, when they were enacting, they ignored this particular minimum number count. So then they inserted subsequently 2018 amendment. They added the word section 3A. I think it must be 3A violation, wherein for public limited company 7 people, private company 2 people. It is written clearly.
Yeah, people have got reduced here. So in this particular say, company 2 lakh rupees, 4 directors, 50,000 rupees each. This is what it has happened. Then again, appointment of the non-resident as the MD without the government approval. This is another issue. This has also happened in the public company only. So here again, 2 lakh rupees on the company. The director who is appointed, he was penalized 50,000 rupees because he was appointed without having a necessary appointment. This is what it has happened in this particular company. So these are all the things which are routine things which are happening. We know we are actually calling ourselves to be, core of the company secretaries, core of the expert of the company law. We are professional. We have to ensure the company's act. When I read all the things, I think what is going actually wrong with our profession. That is the thought which actually comes to my mind. And again here excess remuneration. There is a provision is already there. You can pay the excess remuneration by taking the necessary approval, etc. and other thing and all, which can be done actually. But here it is not the case. Suppose there is a misdoubt. Say excess remuneration has been paid beyond the limit which is prescribed. The company 5 lakh rupees, 5 directors 1 lakh rupees each, 10 lakh rupees. This is what it has happened in this particular case.
2 years time is given to ratify the excess commission. The excess remuneration paid. Section itself it is provided.
Secretarial audit. Because it is very clearly says what's the threshold and other things are all there. The secretarial audit is required. The company bills out. Secretarial audit is not done. So company managing director 2 lakh, 2 lakh, one-time director 2 lakh, 6 lakh rupees. This is what it has happened. SS2 requirements. This is another case of Satish Garg. Here they have gone through it, the lapse of record keeping, defective AGM minutes, contravention of secretarial 2. See, secretarial 1 and secretarial 2 is actually our bread and butter. Conducting the board meeting, routinely we are involved. We have been doing it a number of years, and we are actually claiming to be, professional in the Companies Act, etc. How can this actually happen? So this is the thing. Here again, the company, past 6 directors, past company secretary, past CFO, all those people actually face the fine here in this case. This is what it has happened in particular case. Rotational director, not maintained. The section 152 very clearly talks about it. 1/3 of the director are required to be retired in every annual general meeting. That is, the number was absent. There's only one director was there who was retired by rotation, whereas the minimum number is required to 2. That is what they have not maintained in this particular case. So company 1 lakh rupees, past managing director 1 lakh, again past CFO, being a KMP, they have 4 lakh rupees, the company has to pay the penalty. Then again, inadequate disclosure of the financial statements. Related party transaction details were not disclosed, etc. That was the case here. So this has been taken very seriously because, as we discussed also earlier, which has come in the Sun Pharmaceutical case and the practicing company secretary, here is the company's part. You see the amount of the penalty. 3 lakh rupees of the company, managing director, all-time director, company secretary, CFO, all of them have been actually penalized because they are not disclosed. This is what.
Yeah, this section says shall be 3 lakh, shall be 50,000.
Yeah.
There is no
correct.
discretionary power in the hands of the ROC to reduce the penalty. Even if you go to the RD appeal, they are also saying yes, it is confirmed. They are confirming, they are not reducing.
Yeah, correct. Absolutely, you're right. See, the reduction is only possible if the company is extraordinarily facing some sort of the financial crisis, or they are actually, loss-making company, or any sort of the things, then only the RD considers, otherwise he is not considering it. That is very clear. It is seen actually in the recent orders also. Earlier, I used to see the various RD orders. Nowadays, whenever the RD orders I see, most of the RD's orders are confirming the ROC orders. That is what it is actually coming out nowadays. Related party transaction without the proper approval. This is what the case I was actually talking. Company has been left and right entering the related party transactions, giving the reference of a resolution passed 5 years back. That is all, nothing else. This is what it has happened. Because this is one of the Sana lifestyle company, they have actually the group companies. So there's a huge transaction that has been actually taking place. So they have actually taken up this particular issue. In fact, they went to appeal in this particular case actually. When they went to the appeal, they have reduced the penalty to some extent because they reduced the total penalty from 25.98 lakh rupees to 20 lakh rupees. They have actually reduced. That is what he has considered in this particular case. This is what it has happened. Because you see, the law is very clear. Very, very simply, it says there are only 2 things. One is within the threshold, one is above the threshold. Above the threshold, you have to go to the shareholder. Within the threshold, it is with the audit committee. That is very clear. Number 2 is routine transaction. You take the omnibus approval. That is there. The omnibus approval is given for year to year. That is what it is required to have been done in this case. But which has not seemed to be. They taken some approval some 5 years back. Repeatedly, they are putting routinely and they are doing it. That's what it has happened in this particular case. Practicing professional. This is again that SR shipping, initially what I spoken to you. that 2 lakh rupees penalty on the related party transaction. Then again, this is the Sun Pharmaceutical case, what we discussed actually, related party transaction, critical issues were omitted. That has happened. And then in this particular case, incorrect certification of the annual return because were not matching what the company is given. The PCS actually relied upon and put it. This is what the thing which is actually happened. So 2 lakh rupees penalty. See the heavy penalty on this without verifying the documents which is actually certified. That is what it has happened. Probably you would have charged much less for the certification fees, where the penalty itself is very high. That's what it appears to be.
Cannot be. Sir, there are three aspects are there. I will let me pitch in here about the practicing company secretaries. Generally, we give three supports, three reports. So one is the signing of annual return, that is a MGT 7, and issuing a certificate under certain limited matters, that is MGT 8, and then secretarial audit. Okay. If you see the total scope of this particular, all these three assignment, and MGT 7 says the company has complied in one liner only. Company has complied with all applicable provisions of the Act. It is more dangerous than secretarial audit. Because we are giving a statement that company has complied with. If you look at the MGT 7, para number 11. I don't know how many of you just go through that. It says company has complied, made all disclosure, whatever it is, as per the applicable provisions of the Act. One statement you are giving entirety that as a company secretary signing the MGT 7 is also certifying that you have complied under Companies Act. Going back to the MGT 7 at least certain paras are there, like 18 paras are there. Of course, in that also para number A speaks about MGT 7. So you are certifying what is stated in MGT 7 is a correct. So MGT 8 is more dangerous than MGT 7 because MGT 7 is included, it includes even the MGT 7 as well. And compared to these two documents, secretarial audit is very simple document as per my understanding of this. Secretarial audit, at least it say you can just say I have done my secretarial audit based on the test check basis. I have not done entire population check and all. However, in MGT 7 and MGT 8 cases, the PCS is supposed to do the entire population check. Like when you are releasing a new product outside market, that there is a QT technology will be there, quality and so on, so technology. Every product should have a sticker called okay, yes, it can be sold, it can be sold. Similarly, company secretary who is issuing the MGT 7 and MGT 8, one should ensure that all the corporate actions taken place in the company are in compliance with the law. That is the scope of the means item wise scope of the company secretary. So very dangerous these two MGT. But whereas the penalties are very dangerous. Similarly, what you get for as a secretarial auditor is very peanut. For MGT 7 or MGT 8, what hardly you get, even not 10% of your penalty. Secretarial audit also same way. Penalties are there and how much people are charging also we don't know. So a very draconian job we are doing, but our fees are not up to the mark.
Absolutely, you're right, actually. In fact, I can give a small comparison what you actually said. You know, the Caro report used to be issued by the auditors earlier. In the Caro report, what they used to say is, they used to say that we are checking the transaction in which directors are actually, the contract in which directors are interested. That is actually placed from time to time. It is there. We have gone through it. It's okay. That's what they used to issue. Now, that has been actually amended in such a way, the auditors in the Caro report is to certify that all the contract in which directors are interested are really entered by the company, and we are certifying that. So that is what they have actually brought the scope. Similarly here, when you are talking about here the certification, more or less it is something like that. Whenever you are doing it, you will have to be very careful. Otherwise, we will end up in this sort of situations. Again, there is another case, a wrong certification of the return of the allotment by the PCS. This is what it has happened. Of course, in this case, PAS 3 was filed, the company and as well as PCS, both of them were actually filed because they have put the wrong, because the certification is wrong. This is what it has actually happened here. And then, as I said, let me turn to LODR. LODR, it is applicable only to the public limited companies. So the listed companies which are actually there, the LODR goes from time to time. They are actually saying, I just done a small study. When I done a small study, I came across mainly what happens is most of the orders which are actually coming delayed non-disclosure of material events. That be regulation 30, which is actually increasingly seen actually. This is coming on thing because the stock exchanges to be notified within 24 hours the material development, which seem to not happening, either not happening or delayed things which are happening. That is one thing. Second thing is I also come across the board and committee composition, inadequate number of independent director composition, and the record number is not there. Mandatory committee like a audit committee, NRC committee, all those things which I actually come across. 17 to 19 regulations. Then again, related party transaction regulation 23, which is really a very draconian things, which they are very greater detail they are going at. Actually, that is what they are doing it. And again, in case of the high value debt listed companies, they are actually facing a lot of corporate governance requirements because they are actually equally comply with the corporate requirements, etc. Another thing, that is another thing. Of course, the insider trading violation, which is actually seen. These are the various things which are actually coming up under the public companies, listed companies. Now, this is one thing, insider trading. That insider trading regulation here, what has happens first, this is what you call the trading window, which is required to be kept open, which has not been done. The company secretary was taken to the task. Initially, adjudication officer filed 5 lakh rupees because of not doing that. Of course, he went to the SAT. SAT also seen the non-compliance is there, but somehow they're considering the thing, the penalty has been reduced from 5 lakh rupees to 1 lakh rupees to him. Anyway, ultimately it was ended up with 1 lakh rupees. That is what it has happened here. Similarly, the related party transactions, improper approval of the related party transaction, which has actually happened because, as you know, the related party transaction required to be approved only by the independent directors. That was actually the case. So here somehow that they are not taken care of that. So really speaking, in this case, 25 lakh rupees upon the company, 20 lakh rupees on an independent director. That means there are independent director, two directors, 10 lakh rupees each. That is what they have fined totally. And 4 lakh rupees on the company secretary. In total, 49 lakh rupees they have levied the penalty. Of course, they went to appeal to the SAT. SAT reduced from 25 lakh rupees to 10 lakh rupees to the company. And the independent director, they reduced 50%, that is 5 lakh rupees instead of 10 lakh rupees. And the company secretary from 4 lakh rupees to 1 lakh rupees. That is what they have done in this particular case which has happened. Then again, this is the landmark case you are all aware, which was there in the news item also. Because here, the regulator is very serious in looking into the related party transaction. Because the interpretation of the law is that the contract contained regulation transactions, they played with the, English verdicts. They said, although it is a related party transaction, it is not the related party. Something like that they actually started. They have tried to dilute the regulation itself. So regulator is very heavily actually came back on this. They said, sorry, don't play with the laws because correct interpretation things should be there. That is what they have cut very heavily. They said, they use the word, no room for word gaming in the related party norms. This is the wording they used actually in this. Yeah. Because this is, threshold when it is provided to the regulator, whether it is applicable for one particular transaction, all of the transaction, it is, although it is related party, but the transaction is not related party, all those sort of things they have actually done. So they have tried to violate the.
So,
Yeah.
Sir, you are in mute. We are unable to hear you.
Yeah.
Now,
Are you able to hear
please.
me? Yeah.
Now, yeah, please.
So here what happens is in this particular case, they use the word no room for word games because they played with the word related party and related party transactions. Although they are related party, it is not the related party transaction. Something like that they actually brought in. And second thing is there, it is with respect to each transaction, the whole of the transactions. That is what another thing they brought. So regulators very heavily came back. They said, don't dilute the regulations. You have to stick to the framework of the regulations, you have to comply with it. That is what they came back very heavily in this particular case. Again, in case of the Reliance Home Finance, in this case of 2024, material events was not disclosed. Rather, in some cases, there was a delayed regulation. 8 lakh rupees has been penalized in this particular case. Then similarly, there is another company called the MP Industries Limited. Same material events which has not been actually disclosed. Here, this is actually, what happens was they have gone for their settlement. There was a settlement scheme was announced by them. They gone for the settlement. They admitted, yes, it is true, whatever it is, and other thing and all. Although penalty was there, they actually put forward 12 lakh rupees, 35,000 rupees. They agreed for the settlement voluntarily. And ultimately, for hearing the personal hearing, they accepted, they passed the settlement order. Company has to sell out 12 lakh 35,000 rupees in this particular case. Then again, Hindustan Copper. This is again, government of undertaking. So here what happened? The board composition. That means they are not maintaining the required number of the independent director. With the result, the various committee, nomination committee and all those things, regulation 17, 18, 19, these are all got affected. The matter was actually taken up. The company started arguing, one thing is there, we are all the government company. These are all subject to government's procedure and other thing and all, because it is handled by the Ministry of Mines. We have nothing. It is beyond our control. Okay, we have a problem. So all the things they have actually put forward. But ultimately, the regulator said, no, compliance is compliance, whatever it is not required to be done. Compliance is to be done. Some other, in this case, what has happened, NSE and BSE, both individually, because they have the different listing agreement with each of the exchanges. So both the exchanges have come back, each of the exchanges levied the penalty. They have done actually 9,54,800 in combined. That is what they have done actually in this particular case. This is it has happened. Adani Group case is a very popular case. I only just thought of bringing to your notice. There are huge cry was there. There are a lot of media discussion has been actually there. It is actually RPT transaction. That is what it is actually talked out. Ultimately, they have actually come on this, whatever the allocations are and other thing and all. The SEBI was very clear. Pre-2021 amendments of the LODR, certain transaction between the listed company related party did not constitute related party transaction, because it was as of the date when the transaction is taken place. That is what the benefit they have given. So he says, in this particular, even the ultimate beneficiary was a related party. This is not. That is what the finding which actually came out. The matter was then settled in SEBI here. So that's all. With this, I think I come to the end of the discussions. Now I think there are a lot of questions are there, and I will take up these questions before that. Let me go back to the questions.
Sir, you can take up the query that was posted by
Yeah,
Jay.
I'm seeing here. We are talking about
11:52 onwards.
Can minutes be altered after they have been signed? If so, if there is a prescribed time limit, and what is the permissible extent to such alterations specifically, or changes restricted only to the clerical and typographical error? According to me, minutes cannot be
altered.
Minutes
Cannot be altered at any cost. Not any cost. You can pass subsequent resolutions like a partial modification of the so and so minutes and so and so date passed. You can reproduce them with the permission of the board. Probably those clerical mistakes can be rectified. You need to pass another resolution. Like example, earlier we have got a borrowing limits of 500 crores, and that resolution was given to the bank. Now you want to go with the 600, but all other things remain same. Means other terms and conditions are remain same. Today, instead of passing a detailed resolution for borrowing of total amount, you can simply say, in partial modification of earlier resolution so and so now the limits have been enhanced from 500 to 600. That's all. Rest of the terms and conditions of the other resolution remain same. Like that, you can pass. So you need to pass a special resolution clearly in the next subsequent meeting, clearly indicating what is the error. So only through minutes of the subsequent meeting only you can rectify. You can't do manually. If you want to do, it's not correct.
Well, issuance of the certified copy of the minutes without page numbers be treated as a compliance for the purpose of sending the signed minutes? I think we discussed this elaborately.
This was discussed.
Yeah. Can each minute book start with the new page numbers? Say, example, third book starts with a 3/1.
Sir, it is a minute book. One should be aware of it. It is a minutes book. The minutes book from the starting pages till end, should have the same consecutive number.
Correct.
See,
It
if
is
you
written.
take the example, like I have, I think, like cases like Tata's, Birla's, no, where the company is more than 100 years old. You will find the from first meeting, which was 150 years ago, till date, it is like a volume one, volume two, continued number. You must have seen like Ramaya, like having the 4, 5 volumes, but serial number of each page is continued.
Correct.
No, same way we should maintain for minutes as well. You can't maintain minutes, pages for the, minute wise. It's not permitted.
Yeah, it is very clearly mentioned. Consecutively numbered minutes book. That's what the wording is there.
Book should
Okay.
be. It is a book page,
Yeah.
It cannot be subsequent differently.
Yeah. Many directors do not give the disclosure of the being appointed in the new company. How to track this? And it may happen that we miss to take a note of a revised disclosure in
Please keep
upcoming
sending
books.
reminders, sir, along with your notice to board meetings. You keep sending the reminders, sir. Please let us know whether you got appointed anywhere or you relinquished any position. It is required as per section 189. Within 30 days, the KMP and directors are supposed to inform their positions in other companies, whether appointment or relinquish. Both should be mentioned. Mandatory.
My point is that internal auditor is to be present as per the company law. His presence is mandatory and not as an invitee as contained in company secretarial standards and guidelines. Please clarify.
Yeah, it is. See, if you look at the presence of, they are given categorically, like director, yes, he will be there, and company secretary in his attendance, like X, Y, Z as an invitee. In like 3, 4 baskets are there. You have to write in those baskets clearly about clearly. Internal auditor maybe can be outsider also. How it can be internal person? It depends upon. You can appoint any chartered accountant outside as your internal auditor. And he will come, he may do regularly audit, but doesn't mean he's your officer of the company. He has no access to the minutes or meeting. No. I feel he should fall under the invitee. Anyhow, you check once clearly SS1 and guidance note given on this aspect.
I've seen a company where the initial director, both foreigners from different countries in the private company limited team, who stated the company after the company running for some time, some misunderstanding happened and one person started sending notice against the company for compensation, etc. Then finally his share was actually purchased by the other major shareholder director. And the minutes should be written very carefully, going the facts clearly, and the viewpoint of all the directors should be taken note of, especially if there are diversified views. Yeah, that you'll have to take, because minutes has to represent the facts. That is what it very clearly says.
Correct.
In case of the circular resolution specifies an effective date earlier than the date on which the board approval actually received, we shall be considered the date of the posting and the effective date of the resolution. You see, circular resolution, again, the majority who votes, that is the day the resolution is actually said to have been passed. But really, whatever the time limit is given, you will have to wait till the time limit. Although the resolution is said to have been passed when the majority number is obtained, but still you will have to wait till the time limit is actually given. That is the thing.
Yeah, that's correct. But if you look at the SS1 6.3.2, you have answer. It is written clearly when this particular meeting or resolution is said to be passed. 6.3.2, it has two subparas A and B. You just carefully read it, then you will come to know that when it is going to be active. So there is a concept called some director, like 1/3. 1/3 of directors may ask you at any point of time during the 7 days time of your circular notice, circular resolution time. They may ask you, even you got 51% consent in the day one, but there is a chance like 1/3 director, they may ask you to go for a meeting. Let this item be discussed at the meeting, not through circular. What you will do? You have to place that in the meeting. You can't consider because there is a 51%. No, it cannot be. So I suggest you read the 6.3.2. You will get answer for this.
We keep the minutes in the loose leaf folder. These minutes are required to put in the physical book folder periodically. Yes, it is required to be bound from periodically. That is very clearly there. Please go through our guidance note also on this. On short point is there is no timestamp of recording online. Yeah, that is what he discussed actually about the software,
No, I
etc.
have
in the
told you very
beginning.
clear. I don't know. See how many of you are there. Like timestamp, your own ROC receipt. When you file a form with ROC, with SRN, you will get even minute second also recorded when you have filed this form. That is timestamp. So when you are doing with anything online using the internet and if you record it, you will have certainly, even though it may not be visible in your minutes, but in-house, in the system, the timestamp is recorded. Timestamp is something like this was created on so and so day to prove it, or so and so time it was created. So timestamp, if the proper design is there in the minutes, if you are maintaining offline or whatever it is, online and all, if that your developer is properly designed, no, you will certainly see the timestamp when these minutes were created. Like best example to you, suppose you earlier in the olden days, cameras or even nowadays in cameras, you can have the time and date and place printed on the photograph. When where it is with including GPI, address also. That is exactly the timestamp. It may have location, it may have time, it may have place also. So you should have ensured all these things when you want to go with exactly online minutes.
Gives an appointment of a person as a independent director without going through the examination.
And we don't suggest to go with that person. Okay, next.
Okay. How about taking the board approval for waiver of the circulation of the signed minutes? Yeah, that is a procedure is actually there. That you can do, I think, in my opinion.
If see, it is a statutory right of the director participated in the minutes to have the signed copy. It is his own protection. But there are some big companies, they don't want circulate the minutes. They don't want circulate the minutes because once minutes are circulated to the director, they are not confident that that minutes will not be shared to anyone else. So those cases, they are getting some, kind of waivers. But by and large, as per SS1, the signed minutes taking or getting signed copy of minutes from the company is a statutory right of a particular director. Since it is a statutory right, maybe he can waive it off. It is his own right.
Draft minutes already circulated next to board meeting agenda, full minutes inserted and circulated to all the directors. That's what he said. Anyway, we discussed that. What is the meaning of continually numbered? Does it mean the minutes pages of that particular meeting should be continued number or this numbering should continue in various board meetings?
Yeah, it should
See,
continue from first board meeting.
can an auditor seek exemption from AGM, EGM via email or we just have to inform?
No, the procedure is simple. So, as per 101, you are supposed to serve a notice to the auditor, including 146 also. So, communication goes from the company that when the board meeting, when the general meeting is going to be there. Now, auditor has to decide whether he should come and attend. Attending is a mandatory as per 146. If he doesn't want to attend, then he should certainly seek specifically either by mail or whatever it is. He has to write to the company that he doesn't want to present. So kindly grant the leave of absence. So then only company can grant. Company cannot grant leave of absence on its own. Here the company means could be a board of director, need not be shareholders at the general meeting. The postal ballot is again the kind of a business decision making process. The notice of the postal ballot circulating to the auditor is also legal right. It should be sent. Though there is no meeting, even he doesn't need to come, but he should get the communication about the decisions to be made by the shareholders.
Whether it is a mandatory for the secretarial auditor to attend the all general meeting.
Yeah, see, if you look at the SS2 and para number 1.2, sending of notice of every general meeting to the auditor, including secretarial auditor, is a mandatory by the company where the secretarial auditor is appointed And para number 403, it is a mandatory to the secretarial auditor to attend the annual general meetings. That's the word they have used word. Annual general meeting. He has to attend that annual general meeting. And he also has one more right to be heard if there is any item concern or associated to him. If there is an item going to be discussed by the share, like example, removal of auditor or whatever it is, I'm just giving idea. So that time, this particular auditor, secretarial auditor has a right to be heard. Whether he can seek the leave of absence, yes, he can seek the leave of absence. There is no problem. So serving notice to all general meeting to secretarial auditor is mandatory. That is 1.2, SS1, SS2, and 403. Attending at the general meeting, annual general meeting by the secretarial auditor is a mandatory. He can seek the leave of absence, or he can even send his authorized representative for the meeting.
Notice as a statutory auditor, CA, for secretarial auditor, CS. Please clarify. I think which we discussed actually is that actually.
Yeah.
If the company secretary signed the personal guarantee for a company loan, he is to be personally liable for repay the debt.
What do you mean personal guarantee? So personally, you have already signed means you are personally held responsible. Like a director has given personal guarantee for the company borrowings to the bank, director is held responsible. Similarly, if the company secretary has signed any personal guarantee to the bank for a loan taken, then he is held responsible personally. Can't escape.
Sir, can you please explain point number 9 above ID appointment without the data bank? Does it mean that ID should be appointed from the data bank? I think there is a
That's
mistake.
what he should
There
be.
is a
There is instruction, sir. He should be there. His name should be there in the data bank. Then only you can make him as a as ID for you.
yeah.
And he
Once
should
you
be qualified also. Continue to be as ID means continuous education qualification should be there as per the data bank.
see, either you finalize the auditor, he has to get enrolled himself in the data bank. That is one. Second thing is whether qualification is required or not required, that he has to see. So those things we will have to see. But anyway, his appointment should be actually, when you are appointing, his name should be there in the data bank. He has to ensure that. That is the thing. You can identify the person, but he can always get enrolled in the data bank. But the only thing is appointment can take place only after that. Without a data bank, you cannot appoint. Nowadays, we have observed that even we go with a request to mark a form of NTPR so that a revised rectified form can be filed with the ROC as imposed penalty. Is this correct spirit of interpretation of the law?
We can't tell anything. See, the problem ROS how we will view. Suppose you filed a very crucial document and with wrong data. Like best example, pass 3 was filed with wrong data. Now you are ready to revise, but ROC says no, no, no. In the earlier pass 3, and you stated clearly at the end that I've seen verified all those things. Despite of that, you mentioned the wrong data. Because you are ready to file rectified form, why I should not penalize you? So I will penalize you, after that you will rectify it. That's what some ROCs are taking stand. So we can't say that whether ROC is correct or not.
In case of the private company, not meeting with the threshold appointment company secretary, appoint the company secretary. Does the company has to comply with all the provisions, section 203 and other acts? Of course, once you appoint the company secretary, automatically you have to comply with the record sections. There is
See,
also
I will
one.
tell you one example for this, sir. Let them look at the section 134, signing of the balance sheet by the company secretary. The section doesn't say the which company secretary should sign, whether the company secretary appointed under the 203 or any other companies. It simply says if there is a company secretary, if the company secretary is appointed, that much only is given. Similarly, wherever the word company secretary is there, for all practical purpose, whether he was appointed as a under 203 mandatory provisions or voluntarily appointed, he is the company secretary for the public, and if any non-compliance is there, he has to face the music. There is no other option.
There is also one recent order of the ROC, Pune levying penalty for delay of issues of state certificate for 3 days. Yes, that is there very clearly because they are all nowadays meticulously looking into the non-compliances. That is very, very clear. If a director has not done the KYC, whether the director can resign and file DR12 without doing KYC?
I think without KYC, the DIN number will not be active.
Nothing can be done.
The data will not get printed.
KYC is
Only
required to be
one
done.
situation. No, correct. In one situation, suppose there is no KYC done, DIN is deactivated, and the person died. Okay. Now you can't deactivate, means you can't file the KYC for that particular person. In such situation, even though DIN is deactivated for non-filing of KYC, you will be able to file DIR 12, provided you select that button called death. If you select the death button, then system, I was told, system will allow you to get that man deactivated, DIN also get pre-filled his data, and you will be able to use that. If you are not able to do in such case also, you have to raise a ticket, and MCA people are enabling filing of cessation of the death persons. Even though DIN is deactivated, non-filing of KYC, you don't need to file a KYC. You will be able to file DR12, but not other cases.
What about the resigned director if he has filed a DR11? So they are safeguarded. Yeah, that is right. That he has discussed actually. What will be the minimum number of the members required to the private limited company, which is subsidiary of the public limited company?
Yeah, here we need to look at the definition of public limited company. I think 2 class 71. It says public company means which is not a private company. Then goes on saying that clearly a company which is a subsidiary of another company, then they say the another company which is not a public company for all purposes of this act shall be deemed to be a public company where such private limited company has article related to the private company. It says, in other words, the section mandates you, and rather section identifies you as a public company for the purpose of compliance of the provisions of the act. For the purposes of this act, that is the wording is used it. When for the purpose of this act, so means section 1 to section 470 are part of the Companies Act. So example section 3A, just now I told you, the public limited company 7 members. Similarly, section 3, I think 3 or 4, where the creation of public company, wordings are there the 7 member is there. Similarly, section 104, I think that is a quorum section, where the minimum 5 members are there. Tell me, can you ignore these 3-4 sections? Since you are a subsidiary of a public company, can you have a quorum? Only 2. The answer seems to be no. So as per my understanding, moment you become a subsidiary of a public company, you cannot avail any benefit or any advantage or any privilege or any sort of exemption that is given through exemption notification as a private company. You can't do it because the section clearly says for the purpose of this act, you will be treated as a public company. That's all. So I feel you should increase as per my understanding of the law.
I think it is already 1:15. I think more questions are there. We'll just go through it. So the clarification is that present section 450 for provisions.
That they are going to insert Suyomoto provision.
Yeah, that you already said actually. This is how just
it is going to be inserted.
How to check the related party transactions like a director's wife, etc., and other thing and all. See, there is a guidance note has been given by the institute. Please go through it, which we have been actually saying. Or placing the financial statement, quarterly report, AGM notices on company website mandatory for company under liquidation. Till the company is under liquidation, you have to ensure the compliance. Everything is to be done. Nothing comes to the stop. Can you repeat this?
But once company goes into liquidation, I don't think these things should be placed because these are the history. I don't think you need to place. It may be liquidation under the IBC, liquidation under the Companies Act. Now it is a liquidator's duty. Liquidator's duty is not to ensure the various other past compliances. His duty is to ensure the, what I can say, asset realization and distribution and the compliance during the liquidation process. I don't think you need to maintain website, all the stuff.
Can you repeat the slide of the Sun Pharma and SR slide? If possible, I missed it. Okay, I'll do that before we close. Institute post research need to standard checklist for the kind of major areas.
Otherwise, we can go ahead. Yeah.
Whether MPP1 DR8 or the independent director declaration can be signed digitally and sent to the company.
It can be. I am not finding any problems. In writing, it includes digitally also. And you will be sending through email. So anything that you send digitally, you will send mail so that there will be an evidence. When did you send this? It's not a backdated, all those stuff. It can be
Well,
signed, there is no issue. But tomorrow, ensure that this particular director who has signed or whose DSC is used, he should not go against saying that I have not given digital signature. Who has signed this? Do you have authorization? Suppose you are a company secretary in employment or practice, now you are using the DSC of someone else. Do you have power to use it? Do you have proper authorization to use the DSC? So, in order to avoid all these unwarranted things, better to get digitally, physically signed with respect to director and sent to the respect to company. That is my advice.
there is a website where these cases are reported. Yeah, it is there in MCA. If you go, actually, there is a ROC or the order is
Yeah,
actually
it's there,
reported. You can
correct.
actually see it. Being the government company, not public interest
More
of the
public.
involved, so they
It
should
is-
actually stricter complaints. They
Yeah,
are
yeah,
actually handling.
some
Yeah,
advice.
that is right. Can we place administrator oversight in putting the wrong date of the director attendance in MGT 7? Related party transaction material disclosure has first been made in the clear in the Companies Act 2013 or orders passed or based on the
Advice
what is
only.
that?
So many are there, sir. Around 30, 40 are there.
Okay, if a listed company has the director, out of which 4 are independent director, one is the managing director, one is the non-executive director. If the managing director is not liable by notice by rotation due to the provision of the article, can only one non-executive director be liable retire by rotation
No, that's
every year, or it is, see,
that
read
is
section
not that is not
152.
correct.
This is not correct. 1/3, you know, to calculate in the total number. That is very, very clear. It is a running storybook with no end. Probably it will run on the companies with the right. Okay, that is right. These SEBI orders are very clearly enunciated based on the SEBI LODR Act and ROC penalties, PCS based without a daily, and what you think actually. SEBI orders are clear. No, see, it is all independent because you have gone for the listing agreement, you have signed the contract, it's a contractual obligation. ROC, you are actually incorporated under the thing, it's ROC. It's all two different things actually. Meeting number can be year-wise.
Yeah, meeting numbers, I think Institute has already given through the guidance note on SS1. It can be year one, like 2026, year one, year two, like that. Meeting can be there. It is possible. So
Can a
consultant cannot attend general meeting. Okay, go ahead.
consultant can be an innovative. Yeah, if he is there, innovative.
No, general meetings they are telling.
No, general meeting, no.
Not boards.
No.
What
General
did you
meeting is
do
only,
in the general meeting?
yeah, only for the shareholders.
It is a private meeting, no?
Will the issuance of the certified copy of the minutes without which we treated this to be discussed, I think so.
Yes, yes,
Sir,
yes.
sorry to interrupt, but we have already reached 120, so I think we can go quickly.
Disha, we'll stop it. I think we will not
Yeah.
able to answer all these questions.
Okay. Then I think,
Many are there.
okay, let me see one thing. Any important things are there actually?
Many are there, sir. Another 40 questions are there.
Okay. So I think we'll have to call it a day then here. We are already 120 as he rightly says. Okay, before I close, I would like to actually end up with a quote again. Same, our father of nation actually said, if we could change ourselves, the tendency in the world also would change. As a man changes his own nature, so does the attitude of the world also change towards him. We need not wait to see what others do. So that will you be the change, what you want to see in the world. That is a short form. So we have to actually set it. In the beginning, I started with the change. We need to adapt to the change. That is one thing. Second thing is I said actually let us practice the better governance, going beyond the regulations. So it's definitely practice the better governance practices will act as a differentiating competitor among the competitors. It will lead to definitely a customer delight. That's what I would say. With this, I come to an end. Thanks. I stop sharing the things here.
Thank you to the all participants. So we were not able to address all the questions due to the paucity of time. Now that next time we will try to address it. Thank you to the Mehta and Mehta sir, Balakrishnan sir, and Disha and Dipti Mehta madam for providing me this opportunity to be part of this knowledge share. Thank you to all. Good day to all. Bye.
Thanks a lot, Tripal, for your really sharing the practical insight of this. I'm really privileged to be in this program and meeting so many people and interacting with them. As I said in the beginning again, really I am delighted. People are all interested in knowing the thing. People are all seeking clarification. People are all going forward. That's a very positive side. But the only thing is at the end of the day, I want to see less number of the adjudication orders, not so many non-compliances which are coming actually. That is what. Wish you all the good. Thanks a lot.
Good night.
Thanks one and all to everybody. Thank you.
Yeah, good night. Good day.